Knock, knock, Will.
Who's there?
Newsom.
Newsom who?
Knew something went wrong again.
How's it going?
There we go.
Fun Friday.
Attaboy.
If you'll remember, the President of the United States called in the National Guard to help restore order in Los Angeles, where these riots were taking place. They were setting the cars on fire. They were trying to block federal law enforcement activity. They were legitimately trying to stop ICE from carrying out the laws of the nation. And what the president did was use the National Guard to try and assist that when the local authorities were stretched too thin and unable to restore order. And what did Gavin Newsom do? He immediately sued the Trump administration in federal court, and the district court gave him a temporary restraining order, which meant that the president of the United States would have to return control of the National Guard to Gavin Newsom, of which he could order them to go home. Well, the president appealed to the Ninth Circuit, not normally the most friendly jurisdiction, but we've seen a lot of changes because of some of the Trump appointees in the first administration. They received the appeal from the administration to try and get rid of this order from a lower court blocking President Trump from using the National Guard. That court initially gave an administrative stay, meaning that everything was status quo, that the president still had authority over the National Guard. That is normally when they just want to pause things to then hear the facts of the case instead of making a whiplash. But then we have what happened today.
Well, because I don't understand if you're going to say when you sue, when you do this and say President Trump can't do this, it's saying, yes, precedent for a while has been that this has not happened. However, if there's no use, if the president cannot actually call up the National Guard, as they say, what's the point of even having the National Guard? If you have to now play politics with it, there's no reason for these departments to exist. And this seems to be a kind of a running trend, which is, if it hasn't been used in X number of years, that means it should not be used at all. Well, then it shouldn't exist at all if you feel that way.
Well, and what the argument of the state here is that normally when the National Guard is called up, it is in agreement between the president and the governor.
Right, when there's like a disaster.
What was here is that there is a conflict between the governor and the president. And the governor was arguing that the laws that allow for the president to do that when something cannot be carried out or there is total loss of control, the governor of California was arguing, we had it under control, you made it worse. So that's the argument in court, right?
Yeah.
Well, what we get here, and this is a great line from the opinion from the Ninth Circuit that I want to read to people because they granted the stay. So now while this goes through the court system, they can't be ordered to overturn, to make the president hand back over control. Now, obviously, I think California could take the TRO issue up to the Supreme Court. I don't know if they would want to take that right now. But listen to this line from the opinion. We are persuaded that under long-standing precedent interpreting the statutory predecessor to Code 12406, our review of that decision must be highly deferential. Affording the president that deference, we conclude that it is likely that the president lawfully exercised his statutory authority under 12406 subsection 3, which authorizes federalization of the National Guard when, quote, the president is unable with regular forces to execute the laws of the United States, end quote. That is precisely what the president was arguing, that the entire riots and protests they weren't just speaking out. Their entire mission was to stop ICE from carrying out the immigration laws of the country. This is a federal law enforcement, and the president, under the law, can use the National Guard when the federal law is being blocked and unable to be carried out. So the court even saw that.
When it comes to the legal precedent, when they're able to work together, it is probably, it's different. The Dodgers put out a thing saying, hey, the ICE came in and we stopped the ICE enforcement. Then the ICE enforcement said, we didn't send anyone to Dodger Stadium. So now there's this kind of conflict going on between federal government and the locals.
That's right. And to Cambria's question, the president under Title 10 of the United States is the commander-in-chief. Well, he's the commander-in-chief under the Constitution. But under Title 10, it gives ways that the president can actually utilize the National Guard, which is typically under the control of the governor. And there are things like the Posse Comitatus Act, which limit the use of the military for civilian law enforcement. But there are other mechanisms within the law which allow for the president to override that because of extraordinary circumstances. What the president is arguing here, in which is a part of the law, is that the president can use the National Guard when federal law is unable to be carried out through normal methods. And I actually understand a lot of caution that should be a healthy hesitance within conservatives even of using the National Guard and military for law enforcement. I mean, we don't want martial law in mass in the country. But what is different here is that the point of the riots, of the protests, aren't just to speak out. Their intended goal is to stop ICE from being able to enforce federal law. Yep. They want ICE out of California. That goes to direct statutory language of when a president could use the National Guard to help supplement the enforcement of federal law. And so that is what we're seeing play out. And that's actually what the Ninth Circuit was giving deference to in that opinion today.
I'm actually seeing a lot of people in California right now that are commenting saying, Logan, we are with this. This is what we want. This is what we've been asking for. We're seeing that kind of over and over in the comments right now. We also have a lot of people say, hey, I started listening to your show on KKLA. I'm now migrated over to YouTube because, look, they want to see our pretty faces. It's just the truth. But a lot of people are saying, it's crazy there and they need help. So if their own government won't do it, how many of your friends in California have experienced break-ins in their homes, have experienced their cars being shattered? I mean, it is not, it sounds like we are creating some sort of fear-mongering, but it's not. I was in Northern California a couple years ago even, and they were like, hey, make sure you roll down your windows and take everything out of your car, because then they're not going to smash your windows in to steal anything. And those are signs, like permanent printed by the state or by the city signs that are around saying, hey, the only way to avoid car break-ins in our city, we're not going to do anything about it, is to empty your car and roll the windows down. That is what people have been dealing with in California, and I think there is a lot, specifically our supporters, who have had enough with that.
That's right. And specifically the section of code that they cite in the memorandum to the Secretary of Defense, this is from the President of the United States, is Title 10 of U.S. Code, Section 12406. That's actually what was referenced in the opinion as well. And it says whenever, and then you jump down to the third point, the president is unable with regular forces to execute the laws of the United States, the president may call into federal service members and units of the National Guard of any state in such numbers as he considers necessary to repel the invasion, suppress the rebellion, or execute those laws. So the first two are referring to the other 2 points in there. So there is the statutory language of Title 10 that they were citing and using that. So that's the precedent, and that's the law, and that's what they're arguing in court.